Hello, my name is Rocco Strangio, and I'm the host of the Law, AI, and Money podcast. I bring on attorneys, engineers, and entrepreneurs to unravel the world of AI and to discuss how it'll affect the legal profession. Today, I'm joined with Andrew Gardner, the founder of AK Gardner Law. On top of being an attorney, Andrew has a STEM background in both computer science and engineering. This background has given Andrew a more complete understanding of tech and AI. Andrew began his legal career clerking for the U.S. Solicitor General. Out of law school, Andrew worked at Johnson Law Group and Barron and Budd, two of the nation's leading mass tort firms. There, he worked on virtually every mass tort litigation, from Roundup to Hernia Mesh. As someone with vast experience in both tech and law, it's a privilege to have Andrew on as a guest. We hope you enjoy our conversation. Hey, Andrew, how you doing?
I'm good. How are you, Rocco?
Very good. I want to thank you for taking the time to come on. I know you're really busy, and so I greatly appreciate you taking a little time out of your day to come on and talk to us a little bit about AI and mass torts. For those of you that don't know, I got in contact with Andrew. He did a CLE presentation on utilizing AI in your law firm, and I knew I had to get him on the podcast. And so if you could, Andrew, just quickly go into your background, how you got involved with mass torts, and what was the foundation for your understanding of AI?
Yeah, so it's really kind of a funny story because I first found out that I liked computers back in college. Took a couple of computer science classes and realized this is great. But I still wanted to go to law school, so I didn't end up going the computer science route, becoming a software engineer and all that route. But I still keep those programming skills sharp. I still code a little bit here and there on the side. And then after law school, coming to Texas, taking the Texas bar, I just kind of fell into plaintiff's work, and specifically fell into mass torts. I've worked at a couple of really big mass torts shops, and that's been an incredible experience, especially because with mass torts, you have so many cases, so many clients, that, you can't look at every case by hand. And so you've got to find ways to automate, to standardize processes, to leverage technology, and especially on auditing side, where you have to make sure that your data for your 5,000, 7,000, 15,000 cases, whatever it is clean. So if you find inconsistencies in how your cases are documented, technology can help you find those and help you clean those up so that when settlement time comes, you're not sitting there with a giant mess that you've got to go through by hand.
Mm-hmm. Which law firms were you at, and what cases did you guys work on while you were there?
Yeah, so I started at Johnson Law Group, my first mass tort firm.
Okay.
I did some single injury stuff after that, and then I was at Barron and Budd out of Dallas.
Oh, wow.
And between the two, I've worked on basically everything. My first was Risperdal. My favorite was probably hip implants, but I've done some part of Xarelto, talcum powder, knees, Roundup, 3M, Hernia Mesh, TVM. I've been all over the place.
I mean, those Houston firms, I tell you, they on Richmond Ave. Mm-hmm. That street, there's got to be like 10 of the biggest firms,
Yeah. I don't know why they're all there, but there are a ton of firms right there.
There's a hub in Houston and, frankly, all of Texas. Like you mentioned, Barron and Budd out of Dallas. And then, yeah, there's so many firms. So that's great. You obviously have the experience side of it. What do you foresee AI's role being in mass torts apart from just managing claimants and claimant data?
Yeah, so I think there's a couple of things that, especially in mass torts, AI can be really useful for. And I think one thing that some firms have done that a lot of them should be looking at is having some kind of client-facing portal where clients can go and get a status update on their case. Even if, like right now, without AI, you could have a static thing where if your case status is in this stage of whatever, you could have a status for it. Or if your hernia mesh case in this jurisdiction, here's your status update, and it could be a static thing. With AI, you could have a bot that pulls in some selected information from the case and gives them a more interactive experience where they come in. It's like, hello, we're your electronic assistants. What do you want to know about your case? And they can ask, like, what's going on? And they can explain to them what a mass tort is, what a consolidation is. And I have so many of these conversations with mass tort clients where through the intake process and everything, no one sat down and said, you're an individual case, but you're part of a consolidated litigation. And here's what that means. And here's what it means for you. But that conversation, that explanation can come from a bot, either in text, or there are some really good AI tools that are doing, generating audio. And so you could have an actual seeming human person explain this to them verbally, because a lot of clients, they don't want to sit and read all that text. And I would say, it would probably be good to label that as an automated assistant, but I think client outreach is going to be one of the biggest sides. And then especially on the e-discovery side, in the bigger litigation context, e-discovery is going to change a lot in the next 5 years.
I've heard some interesting stuff about e-discovery using these AI platforms that are pretty much free to the public in obtaining documents. But to touch on that underrated point that you mentioned about interpersonality, I think that's huge. I think giving people sort of an assistant that you don't have to, that's a tough job to have. It fluctuates greatly. So having a system, a technology that can do it on its own seamlessly would be great. I understand that lots of claimants in the context of mass torts feel a little bit closed out, like sort of the mass tort being a black box and them having no access to it. And oftentimes there's many years pass before these litigations settle. So that'd be a great tool for them.
Yeah, and if anybody doubts how important something like that is, go look at the Better Business Bureau complaints for any mass tort firm. It's just, and those complaints a lot of times are either a misunderstanding or whatever, but the more that the clients feel like they're getting some kind of outreach, the less likely they are to go lodge those complaints. And so if you have something there where it's like, hey, here's our AI assistant who can explain this to you. If you have a specific concern, that can get escalated to a paralegal or a client manager or even an attorney if necessary. But it's really important.
That almost preserves the integrity of the industry as well. The fact that we have satisfied clients can sort of protect this industry from being so closely regulated and scrutinized in the future. I think it just from all fronts, from having better cases, from client satisfaction, it just makes sense to utilize that. Interestingly, going back to the portal system, we actually utilize a portal system for our post-settlement payments. That's sort of what we do. And we've been trying to use AI to integrate into that portal system as well. But I wanted to talk about discovery because you mentioned it. Is your firm looking at any ways to utilize AI in order to improve your discovery practice?
Oh, absolutely. So a little about me. I've been solo for about 3 weeks. So very much a small shop. It's just me right now. Thank you. Congratulate me when I settle my first case. But it's what I'm looking to do is, and the edge that I think I have over most people having their own personal injury firm, is that I'm leveraging those AI technologies to really speed up, especially discovery, because excuse me, sorry. If you're a defense counsel and you send your discovery requests and then you get back fully responded objections, everything, get that back in an hour, I think that sends a really aggressive message that I think can be, I want to see how they react to that kind of response, to have that pace. I don't want to be the guy who's sending the responses to discovery at midnight the day they're due. But there are a lot of the even just publicly available tools by default, things like ChatGPT, Claude, I think does this really well, can already do these things out of the box. And so in the CLE talks that I give, one of the kind of party tricks examples that I demonstrate is you upload the petition, the discovery requests from the defendant, and the demand letter. And you tell it something simple like, take the facts and allegations from the demand letter and the petition and generate objections and responses to the discovery requests. And in 45 seconds or something, you have a first draft. And so then you just have to go through, punch it up a little bit, add information that it didn't have, and you're done. And so just the other day with my initial disclosures under the Texas rules 194.2, I did those in under 10 minutes because I gave Claude the rule, the information I was required to disclose, a little bit of facts about the case, and asked it to generate the initial disclosures. Copied that into Word with the caption and punched it up a little bit, and I'm done.
That's unbelievable. And, I think just talking to you right now, it seems that you're well on your way to being successful with your law firm, because a lot of these firms, despite their size and prominence, they are a bit antiquated when it comes to their technology and their procedures. Like if something isn't broken, they're not going to fix it. It costs a lot of money to invest in that stuff. And so since you have the background already in this tech and computer science, you just understand it. So that's awesome.
Yeah. And I mean, the biggest thing that I think people don't understand or aren't willing to do is it's not even so much the financial investment, because there are firms that will put the money into the problem for automation or efficiency or whatever. But the issue is that it's time on the front end, because you really need to sit down or have consultants come in or something. And I'm not a big fan of using consultants for this, but you need someone to sit down and be like, okay, what are our processes? And what's the ideal process, the standard operating procedure for a case as it moves through? And you've really got to sit down and think these things through, kind of standardize things, and then find the tools that can best fit each of those steps. And so for me, opening my own practice right now, I'm doing this right now, where I'm evaluating case management softwares. And really what I've done, I don't have it here in my office, but yeah. I sat down, I'm like, okay, intake. What documents need to be generated? What tasks need to be done? Which tasks need to generate other tasks? Which ones? What's the flow chart of that intake process? And then once you hit whatever trigger it is, for me, it's, signed the representation agreement or signed the consent to associate, then it flips over to your initial stage on your actual case, your pre-litigation or treatment or whatever you want to call it. What tasks need to be there? How do those tasks flow from one to the next? What documents need to be generated? And once you have that all sketched out, literally for me, it was pencil and paper on graph paper. Put your flow chart down, document that, and then go to your case management software or start looking at your technology and say, okay, this document needs to be generated every time. Can my case management software automatically generate that the second it hits that stage? Set up that trigger. These tasks need to flow. So set it up so you have like a checklist or a task item in your case management software. And when the paralegal or the staff or whoever it is completes that task, it opens up and assigns the next task to the next person. And then once you have all this set up and you've found technologies that help automate and whatnot, then you have to train the staff. And the hardest part is you really have to say, okay, this is our system. And part of your job, part of your work for this firm is you have to use this system, because a lot of times people put a lot of money and time into this, but they don't enforce it. And the shift, the learning curve, the change is going to be tough on a lot of staff, on a lot of people. But it's really important, if you're going to put the time and money into setting this up, that you have people using it.
Yeah, that's awesome. And I agree. I think there is a learning curve. So the fact that some firms might not, because from what I've seen in some firms, it's optional. Like they have AI tools, but it's optional at your discretion. It can improve your practice and your ability to lawyer or to be a paralegal, but like you said, it's optional. And so I hesitate a little bit, because how do you know, for example, for me, I do utilize AI technologies, but I'm in that phase where I don't quite need it right now. And so I'm not quite learning as much as I need to about it and using it as much as I need to in order to get that 100% learning curve threshold.
And it's actually interesting. There's a phenomenal webcomic called XKCD, very nerdy, but they've got a particular comic where it's like the automation curve. And so it's like a straight line of here's how long it would take for me to do this task by hand. And then it's here's how long it would take for me to automate it. And at some point, the amount of effort it takes to automate something means it would just take less time to do it by hand. And so that's part of that process of evaluating your process procedures. It's like, yeah, I can draft this document in 5 minutes, or I could spend 40 hours setting up a system that would automate it.
Exactly.
How many times am I going to generate that 5-minute document that automation is really going to help me out? And so figuring out that balance of the costs can be really challenging. But I think at the very least, because AI is already so prevalent, and because it's so powerful, the rule of technological competence under the ethical rules, I think, is eventually going to require knowing how to work with AI. And so at least, like you were in my CLE yesterday, at least taking some CLEs on these things, knowing what's out there and finding ways to maybe at least experiment with it can be really useful as things progress.
I recently had a Microsoft software engineer on, and he was telling me about how Microsoft has their own ethicists and AI lawyers. Have you, and what do you foresee being the ethical dilemmas that are going to plague the practice of law if we have widespread use of AI? And I don't say plague as in,
Yeah.
it's a negative. We need those rules. But like, for example, the rule for zealous advocation, right? We need to be zealous advocates for our clients. Is using an AI system zealous advocacy, for example?
Yeah, I think, there's a couple of pieces to the ethical implications of AI in legal practice. I think using AI to be a zealous advocate for your client is great. I don't think that there's an ethical issue there as far as zealous advocacy. The two that I see, and I'm on the task force for AI for both the State Bar of Texas and for the American Association for Justice. So we're talking about these things already. And the two main issues that I hear from people that I see coming up, and then especially I see from judges, is first, like I said, competence. The ethical rules require us to be competent with technology. And that's going to include knowing how to use these tools. And with AI research, as that becomes more available, especially through Lexis and Westlaw, I think that shift is going to be similar from the shift from books to internet research. And it will no longer be ethical to use terms and connectors basic searching for your research, because AI search will be so fast and so efficient. It's hard to justify billing your client 50 hours for something when you could do it in 2. But on the other side is the confidentiality aspect. And this is the thing that scares people the most, because they don't understand where their data is going. It's a little bit of a black box. But I think with ChatGPT, you can opt out of the information you're giving it from going into their model to be trained, and training their model on it and using it and that kind of thing. Claude will opt you out by default, and especially as companies build tools on top of these models, typically the information through the API does not go into the model for training. And so I think as long as you know where your data is going, and you're making sure that client confidential information is not being sent off to train the model, I think at this stage you're in a pretty good place. As things go further along and we understand more, and these companies give us more information about how they're using data, we may get better and better tools. So like for right now, I would not put medical records into ChatGPT or Claude. Claude at least is advertising itself as SOC2 compatible, HIPAA compliant through their API, but it's not clear to me from their web portal, the chat bot you can talk to, that's really protecting that information. So I'd be cautious with things like medical records, trade secrets, that kind of thing. But if it's attorney-client confidential information, that model's not training on the information that you're putting in there, I think you're pretty safe. And we see that with the guidance that California and Florida put out, where they basically said, don't put attorney-client confidential information into models that are going to train on it. I think Florida used the phrase self-learning model or something like that, and that's what they're talking about.
I also foresee an issue with third-party sites that basically integrate the ChatGPT model and technology onto their site. And let's say ChatGPT has protections in place to protect precious data. These third-party sites, with the convenience that maybe they cost less, they use that same technology, but they don't have those protections in place. So I think it's going to be maybe good for the market. Will desaturate a little bit with all these technologies coming out, because some will know they're foolproof and protect our data, but we need to be cautious of that as well. There's
Yeah,
lots
and
of
that's a really big thing, because and something I talk about in a lot of my CLEs is be careful who your vendor is, because for anybody who knows how to code, it is trivial to spin up a website and to start an AI thing based on ChatGPT. And so then you have the question of like, okay, this website that advertises itself as a, document summarizer of some kind, are they taking your data and using it to train their own, custom trained model? And how are they using that data, even if they're also passing it along to ChatGPT? And so even with legal tech vendors, it's important to ask those questions when they come in waving around their new AI buzzword marketing thing. Okay, where's my data going? How are you using this? Are you training your own model? Those questions are really important.
Yeah. Even so, as the data becomes more and more valuable,
Yeah.
The AI systems, that's what they run on. And there will be a boom of data as well. AI uses data, but it also creates new data. And so we need to be...
It does, but it's really interesting. I saw somebody probably on Twitter making the analogy that like in certain areas of science, they need metal that has not been tainted by radioactive material. And so once they started doing testing of nuclear weapons and whatnot, a lot of the steel and iron and whatnot around the world has trace levels of this nuclear material. Mm-hmm. And so what they've been doing so they have untainted metal is they're going and finding shipwrecks at the bottom of the ocean and taking untainted metal out of those shipwrecks. Same with the data that we've got on the internet now. A lot of it's tainted by AI, and it's tough to tell like what data is AI generated and what's not. And so having human created data for continued model training, it's going to be really difficult. And like, it's going to be like trying to find the shipwrecks. Where's the untainted non-AI data? Because it used to be posts on Twitter and Reddit and whatnot generally were human created. Now it's so easy to spin up a bot and have it spouting ChatGPT stuff all over the place that the entire internet is going to be AI.
We'll increasingly have more data be AI generated, mm-hmm. almost exponentially.
Yeah. I think and you don't want to train your model on AI data.
I think the largest companies, Google, Microsoft, I think they have a coalition where they're trying to come together in order to, create rules in order to identify AI generated images and text and data. Because as we know, that's a big problem and could be a great solution if we had some sort of metadata within all these AI technologies that allowed us to identify something as being AI generated.
Yeah, and that's really difficult because one, Google for its search engine optimization is trying to punish websites that are entirely AI generated and not useful. And you're already seeing a lot of spam websites out there where they just crank out 100 articles a day on something that's just nonsensical AI keyword buzz. But even outside of models like Google's Gemini, ChatGPT, Claude, Microsoft with OpenAI, there are open source models. If you have the resources to build a PC with a couple of graphics cards in it, you can download Facebook's open source Llama 2 model and spin up your own in-house AI model. And then you don't have to have those checks, those safeguards, that metadata that identifies your data, your text as AI generated. And, people will use that for nefarious purposes, or, you can just circumvent whatever checks there are out there. So it's going to be really tough in the future to figure out what's AI and what's not, and find out what you're dealing with.
My last question, do you ever foresee a future where you, as an attorney for AK Gardner Law, will be litigating in front of an AI judge?
No, I don't. I don't think that we'll ever get there. And there's a few reasons for that. Is one, we have this system of I don't want to call it political power, but like you'd essentially have to ask the judges to give themselves up to AI, and no one's going to want to leave the bench and let a bot take their place as a practical matter. But even then, I think what a lot of AI researchers know, and what I would hope that anyone trying to implement this would recognize, is that all of these models have a ton of inherent bias built into them. And so Claude, as a model, they have what they call a constitutional AI, where they're trying to give the model a moral constitution to try and work out this bias. But you have the training data going into these things includes so much text that is either, from really terrible places, corners of the internet, or it's text from when, women couldn't be lawyers or Black people were considered property. And that text is just sucked up into this thing, into these models. And that when it's trying to figure out what text to generate, it's drawing on the text that has those biases built in. And so if you have an AI judge who's trying to look at these cases, it may have those biases built in, and it's really tough to identify whether it's considering biases or not. Or you get to a point where you have like just a straight, economical or amoral analysis where maybe the AI judge says, well, historically, Black people's earning potential is, lower, so we don't care so much if they go to jail or something. Not recognizing that the reason their earning potential may be lower statistically is because of systemic factors or whatever else it is. I think that there's too much of that risk of bias that could cause real harm for that to be implemented. On the other hand, though, a lot of facial recognition technology out there has the same biases and is being implemented anyway. So maybe I'm wrong.
It's so tough because that keeps coming up, biases. But on the flip side, to be a devil's advocate, the fact that it's a lot of power to give something a foundation, a moral beacon to judge. Imagine Google's like constitution, basically. That's a lot of power and authority to leverage across a lot of systems, a lot of people.
Yeah, well, not just that, but Google's motto used to be "Don't be evil," and they used to have a provision where if they were in some kind of meeting and they're talking about a software product or talking about a decision they're making, it used to be you could say, "Hey, I think this violates the "Don't be evil" clause" or whatever," and they would stop the meeting and they'd say, "Okay, let's talk about this. Let's figure out, are we doing the morally wrong thing? Are we being evil?" They have dropped that as their motto. They've dropped that from their corporate culture. And so I think trusting private companies whose, at the end of the day, primary goal is profit for their shareholders with something like judicial power would be inherently dangerous. And then building in the AI bias with that just would be a horrible mistake.
Wow. Well, it seems like the conversation is going to keep going, Andrew. But I thank you for coming on. Your expertise is well valued, not just from me, but probably from my viewers as well. I think this episode has been great. And we shed a lot of light on the industry, law, mass torts, and the future and all your predictions. So thank you for coming on. I greatly appreciate it. And I wish you the best with your law firm.
Thank you. I really appreciate that. Thanks for having me on. And just one quick plug before I go for my firm, akgardner.com. Always happy to talk about this kind of thing. So thanks so much.
Yep. Check it out. Thank you.
Hey, thanks for tuning into the Law, AI, and Money podcast. If you enjoyed our conversation, be sure to like and subscribe so we can keep the conversation going. Thank you.